Please like and share these videos if you are being helped by these videos. Talking about law, talking about case law, whether it is civil law or criminal law, and if you're pro se or you have counsel. This is about where I'm the plaintiff and the defendant died while we were in the appeals court, and its opposing counsel never informed the court. So I'm going to talk about 5 errors as shortly as I can and try to break it down to you even more. The court called the real citations AI hallucination. In other words, they said when I filed this brief in court, it was AI hallucinations, which is unheard of. And not AI, but the hallucination part. And that did I commit AI hallucinations? Did I even ask AI to draft my citations? The answer is no. And you've heard me talk about this, and I'm hammering it down because it's going to be happening more and more and more and more. And then especially pro se litigants, people who represent themselves, have a rough time because you're going up against colleagues. And I'll leave that right there. You can read between the lines. So I'm going to talk about this AI hallucination where they said, this is the most damaging and provable wrong statement in this opinion. Your principal brief, that's my first brief. You have to file a principal brief. They do a reply, and then principal brief, response, and reply. Forgive me for that. I want to make sure I'm accurate. And then you have to file this principal brief. And mine was 69 pages. Filed, stamped, and accepted by the court. Contains this important case. It's Jones versus Life Care Centers of America in 4 places. Table of Authorities, page 5. Argument 1, page 21. Argument 1, page 25. The Argument 3, page 38, with the full Westlaw 2025 Westlaw citation. The court said that my citations appears to be a form of artificial intelligence hallucination that is factually false on the face of the file record. I'm looking at my iPad to read my notes. Jones is a real published case by the Tennessee Supreme Court. Note this, by the Tennessee Supreme Court. Decision issued April 25th, 2025. Before your brief was filed. Now, the case law was before I even got to the appeals court, so let's just notice that. And so, no Tennessee appellate court should dismiss a binding Tennessee Supreme Court case as hallucination when that case is documented 4 times in the file brief. In other words, somebody's telling the truth, somebody lied. They call it an error. Somebody lied. Who did this? Judges don't write all these briefs. These are clerks. They clerk for the justices. Who helped somebody? So the next one I'm going to go on because if I stay on that one, then I'll never finish this one up. The court said that you did not explain prejudice when you did. The opinion states at page 14 that you did not explain how you were prejudiced. Your reply brief, the principal response reply brief, has 4 pages dedicated to that section. The trial court erred in concluding that the appellate suffered no harm from the absence of substitution and notice of Dr. Islam's death. At page 11 through 14, with 5 detailed concrete categories of harm listed and cited. This is a misstatement of the record, not a judgment call. No, just of the record. The court did not find your prejudice arguments unpersuasive. It said that they were not made. I just made them. The title of it is the trial court erred in concluding that the appellant suffered no harm from the absence of substitution and notice of Dr. Islam's death. That's in my reply brief. Mind you, there is no one on the other side because they struck the opposing counsel's record. Put everything that she had filed. And first of all, let me go back. Let's put a little asterisk right here. So before I got back to the appeals court, I had to go back down to the trial court. I had to argue all this before the trial court. First of all, the law says when your client dies, you have no representation unless you put a executor or someone substitutes that's what substitution this is all about. Come on in and substitute. And if they hire you, then you stay. Otherwise, you are out. She knew of the death August the 12th. So how do we are down in that the trial court, let me get it right. And she's defending him, knowing that she doesn't have any authority. Exclamation point. And why didn't the judge say something about it? I informed him of his death. He asked me, he said, Mr. Simmons, Judge Binkley. He said, how do you know he died? I raised my hand. I said, I can tell you I know how he died. I said, when they won the appeals court motion opinion, December the 4th, the first thing you do, you call your client and tell them that they have prevailed. Matter of fact, the opinion comes before the 4th, so you would know they sent it to you from the court. But we're going to use the 4th. And he looked at me, he said, what? I said, when a attorney represents a client, they tell them if they have won or if they lost. That's how I know, she told him. He said, that's enough. Thank you. I have a video of that coming. And so that argument right there is very, very important. It said, I did not make them, but I actually did. Error number 3, the internal contradiction on a party's authority. This is interesting. The court's own or prior order said defense counsel had no authority. They wrote this in an order to represent Dr. Islam after his death. I just spoke about that. The opinion also affirms proceeding in the trial court where that the same counsel appeared and defended every post-motion, substitution motion, Rule 60.02, sanction motions, and the court says no prejudice resulted. The court cannot logically find unauthorized representation in its own proceedings, but treat the identical representation below as harmless. My petition makes this argument clear and in the correct form. In other words, when he died, she shouldn't have shown up in that trial or down in the lower court, in the trial court. She should have noted that. She should have told the judge, he's dead, I know it. And the judge would have said, well, you're out of here. Unless you have any documentation or that Mrs. Islam has signed you on or anything to show you that you can stay as counsel. If not, you're out upon death. You cannot represent a dead person. Next, number 4 said misleading. Rule 19D versus the full absence of substitution. I'm going to break this one down. Your principal brief raised 25.01 and these codes together as a package. This is 25.01, Rule 19 from the Tennessee Rules of Appellate Procedure. Sorry that I'm reading off of this. And 20.5-102, the Tennessee Codes annotated. So I know these are a lot of codes, but hang in here with me. Survival alone is not enough. Revival through substitution is also required by the same statute. The court cited these rules for several principles while completely ignoring the revival requirements in the same sentence of the statute. Your petition in ground 3 correctly distinguished Rule 19, which saves a substitution that happened but was not formally ordered, from your situation where no substitution ever occurred at any stage in the court. Sipe versus Sipes does not cover that fact pattern. That's a case that the appeals court used against me. It was called Sipes versus Sipes. That doesn't apply to me. That's not applicable. That's fine. So the last one is structural impossibility with Mrs. Islam. Your brief argued that the protective order made it impossible to serve Mrs. Islam for substitution, yet the court itself sent May 21st opinion to Mrs. Islam. Hello. So how is the court sending the opinion to Mrs. Islam, but she's not substituted? Do y'all catch that? Now, I can't reach her because of a protective order, but the court can supersede me or can follow their own law and send it to her, the opinion to her. Is that correct? Is that right? Somebody talk to me. I don't think so. Matter of fact, I know it's not. It should have gone, Dr. Islam is dead. They just proved that she is the executor. They kept that protective order on me so that they knew that I would serve her. Did they, at this point, in this case, I just explained 5 points to you, and I know that it was a lot. You may have to watch the video a couple of times, but listen. When you do right will always follow you. I kid you not. And it hurts. But guess what? Hold on. Help is on the way. And I promise you this, that the court made errors. And the bottom line is, I believe that I am correct, that I engaged in seriously with, the court did not engage with my brief. They didn't give me a shot because I'm pro se. But what they found out was there was Wendy Lynn Longmire on the other side, or telling Kelly how a pro se person going to go against me. Why did she withdraw? Why did all those counsels withdraw? Why did the clerks who looked at this brief did not pay attention?